Final case on the calendar for today is Daly versus City of Gainesville. Counsel, you may proceed.
I would like to reserve 3 minutes for rebuttal. May it please the court, good afternoon. I am Sid Ansbacher, Gray Robinson for the appellants, Kevin and Carol Daly. As has been stated in the briefs, this is a de novo action. It is a facial challenge of the residential landlord permitting ordinance of the City of Gainesville. What is on appeal essentially is a due process challenge. It is secondarily addressing the due process aspects of Chapter 83 and particularly 83, 44, and 56 of the Florida statutes. It is our contention that what the city has done with its landlord permitting ordinance is to, in a sense, subvert the standards of the common law of nuisance in Florida as established in Orlando Sports Stadium, as established in the Kirk case, and elsewhere, as well as the statutory causes of action for nuisance in Chapter 893, which essentially, and is set forth from Horace Hunt, from from Professor Prosser, certainly both sides, Judge Wolf and Judge Benton in the Windward Marina case, a nuisance standard is a standard that is to be determined, except in nuisance per se cases, on specific ad hoc facts in a proceeding. And it is our view that in examining 14.5 sub...
But isn't that why cities have the authority to enact or adopt ordinances so that they can make the rules clear in an area that might otherwise be gray?
Judge Benton, I do not disagree that they have the authority to pass ordinances. However, under Hadley, under Reyes, and under other authority of the First, Third, the Supreme Court, the general standard for due process is that one receive notice and an opportunity to be heard in a meaningful manner. And it is our view that there is such a series of irrebuttable presumptions in this ordinance that a landlord does not receive the ability to appear and to argue in a meaningful manner. If one looks at 14.5 sub 2 of this ordinance, what it sets forth is on a rolling 3-year basis, the City of Gainesville marks up whether there are warnings and then adjudications or adjudications withheld against a particular leased premises. That ordinance specifically provides that for each warning, one gets 1 point. It provides that a second point is to be attached to the property in the event of an adjudication, in the event of an adjudication withheld or a similar act by local administrative process or county court. Then, as each point accumulates up to 6, there is a warning letter that goes out to the permittee. What 14.5 sub 3 provides is that upon 6 points having accumulated, and again, there's the word accumulated again, the city issues a show cause notice to the permittee.
At which point a hearing can be requested.
If, however, a hearing is not requested, it creates, in our view, a nuisance per se, because this is a nuisance or noxious use type proceeding. You lose your license in the event that you do not respond. The only things that have occurred at this point are the 6 points having accumulated over warnings et al., to which there is no dispute that there is no independent point of entry to challenge. And for what it's worth, in response to what the city provides, it is our view that if one looks at the United States Supreme Court decision in Connecticut v. Dorr from 1999, in that case is cited in various authority, including City of Oakland versus Abend, regarding landlord permit requirements in that city, the court held that continuing clouds on an interest in property constitute property interest, or rather constitute the sorts of impediments to use of property that can give rise to a due process right.
Or is it clear under the ordinance that the points remain even if the land is sold?
There is nothing to preclude the points from being removed or from remaining. In fact, our view is that it attaches to the property, and the only place where it expressly is removed is in the event that the city hearing officer in subsection 14.5 sub 3 sub b sub 6 finds that there are sufficient actions by the permittee to, quote, seek compliance with the city codes, whatever that means. It is our view under the Florida law regarding the substantive due process rights of the ability to have similarly situated permitted persons be treated similarly, that there is no guidance as to that removal under that context. But what I'd like to point out is, again, yes.
So if you get 5 points, you can ask for a hearing to get some of the points removed?
No, Your Honor. The 6 points is the operative time period.
No hearing of any kind before that point?
No, Your Honor.
But if 5 points had accumulated, the property were sold, and the new owner gets the order to show cause, if that's the name of it, the owner could then say, well, with respect to these first 5 points, I had no connection to the property. And presumably on that basis, those points go away.
If on a new permit, I think that, again, there may be some degree of discretion, but that would be, again, under 4. And I do not believe that that is a mandatory, and in fact, I believe that is a wholly discretionary function on behalf of the city.
Well, doesn't the city have to prove, in addition to these points, that a nuisance, in fact, was occurring in order to revoke a permit?
But again, when one looks at the breadth of what a common law nuisance or a public nuisance at common law is, it started, again, one can look at one Florida law page, I believe it's 48.
All right, but let's assume that we had no such ordinance here at all. There's no ordinance at all. Could a city revoke a permit in the past, let's say, before this ordinance occurred or was enacted? Could a city revoke a landlord's permit on proof that there was, in fact, a nuisance occurring on the leased premises?
Absolutely, and I believe under
chapter. So in a sense, then, adding this point system adds a requirement that the city has to prove, which it didn't have to prove before the ordinance was enacted. It actually makes it tougher to prove.
Except
because now they not only have to prove the the nuisance, now they also have to prove that they put you through this whole drill about the points. As a prerequisite even getting to the point about proving the nuisance.
Your Honor, it creates a presumption that wrongs have occurred. If you look at the Kirk case basically says if a condition on a property creates an inconvenience to the public, creates an unreasonable interference to the public, then that constitutes a presumptive public nuisance. It is our view that the 6 points where essentially without a point of entry.
Maybe there's something about this that I don't understand, and tell me if I have it wrong, but I assume that these points have nothing whatsoever to do with the proof of a nuisance. That stands alone, doesn't it? I mean, it has to be done independently of the points.
Except it is our view that the only thing that you have as a notice to this hearing is the repeated alleged violations. That creates the virtual irrebuttable presumption that inconveniences have been done to the public, whether it's by parking on the grass, whether it's by overflowing garbage, whether it's by having allowed Super Bowl parking.
Pre-ordinance, how would a landlord get notice of the violation?
Previous to this ordinance, it would be a common law nuisance, or you would go under 893. And with 893, there are specific provisions, and again, if I may, there are no prohibitions on defenses, as there are here. The landlord, under subsection D4 of 14.53, is precluded from seeking to defend on the basis of lack of knowledge, acquiescence to, relationship to, or significantly responsibility for any such nuisance.
This is on the points, or this is?
This is on the nuisance. This is at the hearing.
But it seems to, I understand what you're saying on that point, but it seems to me that that's all this point system does, is it takes away this, well, I didn't know they were having, wild parties in the parking lot. Because, well, yes, you did. We gave you points for that 2 weeks ago. It seems to me that's all that does, is to take away the I didn't know it was going on argument, because they still have to independently prove that the nuisance was occurring.
The problem is what you get a notice of is an alleged, whether it's a warning, whether it's an adjudication. You get a notice that an ordinance has allegedly been violated. You do not get a notice that it rises to the level of a nuisance, nor do you have the ability to contest that. It is a fait accompli by the time that you get to the hearing that there are up to 6 separate incidents that could be warnings, or in the best case scenario, 3 separate incidents that result in whether adjudication or adjudication withheld that are violations of the ordinance that, again, should you not show up at the hearing or not ask for the hearing, result in a determination that the permit is revoked.
Well, you've mentioned that several times, and I'm not sure I'm following that. I mean, are you saying that it offends the Constitution and due process to somehow have some kind of a default? I mean, you have a right to a trial in a civil case, too, but if you default, you don't.
But what I'm suggesting is that it is a presumption of the wrong that you have these points piled up. On the one hand, you're saying it doesn't rise to the level of a nuisance. On the other hand, it must arise to something. There must be.
How is that a due process problem, though? If I filed a civil suit against you and alleged something that was totally untrue, but you failed to answer the complaint and I got a default against you, I would win on the basis of the default. It would be no due process problem anywhere in sight. You were served with process. You had a chance to come and argue.
But again, should you show up, those are the offenses that provide the underlying determination of liability. And that you have not, nor even through the hearing, do you have a point of entry to challenge these presumptive violations. You say that, yes, I can defend that there is a nuisance, but I can't plead that I'm not responsible for. I can't plead that I have no knowledge of. And the problem is, what am I left to plead? What am I left to plead? It is principally
that a nuisance did not, in fact, occur.
I don't know that there is a nuisance. Therefore, that is part and parcel of there is no nuisance. I can't plead that I don't know of any nuisance that actually has occurred on the property.
I think you make a good point about the fact of not being able to contest the points at the hearing. I think you make a good point about that. But what I'm still stuck on is this. How does that hurt you if they still have to independently prove that a nuisance in fact occurred?
Because if one looks at the law, if one looks at the depth and breadth of what a nuisance is, it has gotten broader and broader and broader, even at common law, even if one looks at what the analysis...
That's a problem that exists irrespective of this point system, isn't it?
Granted, but the problem is I have 6 points that are there that have accumulated that create this presumption that I have done wrong or have allowed a wrong on my property, even though I have no ability to challenge that.
I thought there was an ability to challenge the points, and that you might be able to demonstrate circumstances which would result in the removal of points.
Not the person who is the property owner, who is the permittee. There is no independent challenge right to those points, Your Honor. It's not a factor. What is a factor is at B5 and 6 of Ordinance 1453 is that the points have accumulated. Again, the exact same verb that is used when the city is looking at whether the points have reached the level for the hearing. 6 points have accumulated. There's no substantive review. The only thing is under subset or under 1453 is that the hearing officer has the ability, after determining that possession has been retaken or that the case has not been proven up, to remove points predicated upon the determination of what efforts the permittee has taken to, quote, seek compliance with the code. And that's it. That's after the hearing. Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Stephanie Marchman, and I represent the appellee in this matter, the City of Gainesville. Before the Court is a facial challenge to the constitutionality and validity of the City of Gainesville's landlord permit ordinance. Specifically, the Dalys claim that the ordinance provides inadequate due process and is preempted by state law. The standard of review in this case is important. Since this case does not involve the actual revocation of a landlord permit, it is not sufficient for the Dalys to interpret the ordinance in a manner which may result in the deprivation of due process. Instead, they must prove no set of circumstances exist under which the ordinance would provide adequate due process. Notably, all of the public nuisance cases relied upon by the Dalys with respect to their main argument in this case, the landlord permit ordinance violates due process because it holds innocent owners liable, involved as applied challenges. Since this case involves only a facial challenge to a city ordinance, it is the position of the city that this ordinance can be applied in a constitutional manner which avoids all of the potential issues raised in the cases cited by the Dalys. On this ground alone, the city's ordinance should be upheld as facially constitutional.
Can you tell us, would you explain to us how this ordinance works?
Well, it's sort of difficult to do. All I have is the ordinance language as well. In practice, not a single permit for the city has been revoked. So I can't tell you how this is actually carried out. This is a facial challenge. So all I have is the ordinance language. Correct. I think in practice what's happening is that the city is working with the landlords once points are accrued and essentially removing points, and this is, obviously not in the record, but based on my conversations.
To get to the point of Judge Benton's question, how would it work? How would it work carried out?
My view of the ordinance and how it would be carried out would be that once there's a violation of 7 specified ordinances, noise, litter, that sort of thing, that a point is lodged against a landlord permit. Once a point is lodged against a permit, the city manager would send a warning to the landlord letting him know the specific violation that occurred at his rental property. After 6 points accrue,
and only then, there's nothing that can be done until the 6 points have
correct.
accrued.
And I would contend that a hearing isn't necessary because when a point accrues, nothing happens to the permit. There's no property interest implicated, so a hearing's not required. It's not until the magic 6 points accrue that there's actually a property interest implicated. So at that point, the landlord permit would be subject to revocation proceedings. Once it's subject to revocation proceedings, the city manager sends out an additional notice to the landlord, and in that notice, it states that they have the opportunity to request a hearing. If the landlord does request a hearing, there's a hearing before a impartial hearing officer, and the landlord has the opportunity to present evidence on all issues involved, cross-examine witnesses, be represented by counsel.
Is there any presumption that arises as a result of the points being assessed?
I know that the Dalys say that there's a presumption, an irrebuttable presumption, but I don't read that in the ordinance, and I think that's where I come back to the fact that this is a facial challenge and not an as-applied challenge. I think if this was an as-applied challenge...
It is true that the issues are very limited at the hearing, right?
In
other words, the landlord will not be heard to say, I didn't know they were having wild parties.
Correct. They cannot use that as a defense, and The hearing officer does look at whether the points have accumulated, and then also looks at whether the property has in fact become a public nuisance. And so the landlord has the opportunity to put on evidence that, in fact, this property is not a public nuisance.
Well, let me ask you something. Suppose the city manager writes these. Who writes the points?
The points are accumulated based on a warning.
Who actually assesses the points?
It's actually the Code Enforcement Division for the City of
Let's suppose you
Gainesville.
had someone in the Code Enforcement Division who really had some ill will toward a particular landlord and really wanted to sort of make book on this landlord by racking up points against them, and issues these 6 points, and there really isn't much to it. And the landlord can't do anything about it but just get the points. Now the landlord goes before an impartial hearing officer who's sitting there saying, well, geez, guy's got 6 points against him. It's kind of a fait accompli already.
Well,
That's what I think the problem that's being addressed here is that this is sort of something that can't be challenged, that's sort of setting up in motion.
I think that the hearing officer would have the ability to hear that sort of evidence, that the Code Enforcement officer had a thing against me and that's why the points were lodged, that in fact there were not violations at this property, and so the points should not have been accumulated against the property. And I think the hearing officer has the ability.
Well, if you can prove that these charges were false, then you're proving there was not a nuisance, that it was a vendetta, perhaps. Tell us, though, about how points can be removed.
Under the ordinance, the points would be removed after the hearing officer determines that there is not a public nuisance or that the points have not accumulated. Then the hearing officer has the ability, basically the hearing officer decides the landlord permit's not going to be revoked, and then has the ability to go ahead and rescind points based on the fact that he has found that 6 points in fact have not accumulated, and recommend dismissal of the revocation proceedings.
So as a unified hearing, it's a single hearing where you ask the question, is there a nuisance here? And as to each of the 6 points, was there justification?
I don't understand the question. Justification for the points? But yes, there should be one hearing.
So you can go behind the points?
No, I don't think that you can go behind the points because the points accumulate based on whether there was a citation or a violation against the property. So in Judge Padovano's example, where a code enforcement officer was just going after a landlord, that would not be sufficient to accumulate points. You'd actually have to have valid citations or violations or warnings against a particular parcel of property.
How do you determine if they're valid if there's no way to challenge them?
Well, I think this case is not unlike a lot of public nuisance cases where landowners or owners in particular are held responsible for other criminal acts that are occurring at their property, and they don't have the ability to, owners in those cases have the ability to challenge the underlying convictions. For example, drug abatement cases where a drug sale takes place at their property. The owner doesn't have the ability to take part in the criminal proceedings involving the drug sale. Same thing with a prostitution conviction. In those cases, the court has said it is okay that you don't have the ability to challenge the underlying acts. But the fact of the matter is, and Judge Padovano pointed this out, is that the whole point of this landlord ordinance is to get landlords to become active and actively manage their properties. And with the point system, they are receiving 6 warnings that their renters are out of control, that there's litter on the property, off-street parking, and that sort of thing. And the idea is that they react and they go and manage their properties. And similarly to other public nuisance type cases where you have drug sales occurring at your property or prostitution, the idea is that the owners are the best people that can actually address those issues at the property. And they're still held liable even though they didn't themselves engage in those actions.
So you say the law is clear that they don't have to even know what's going on? Because isn't that the point here, that this point system imputes knowledge to the landowner?
I think in this case, the landlords are presumed to know because they do get the 6 warnings. And in this case, under the ordinance, they are not allowed to use the defense of, I didn't know this was going on. And I think that this is a concept that is not new under the law. For instance, I recently filed as a notice of supplemental authority of the City of Chicago case, which involved the city's red light ordinance. In that case, they had owners of vehicles which would be held liable for their vehicles which ran red lights, regardless of whether they were driving through the red lights or not. And it would be no defense to the fine or the citation to their running the red light if they didn't know that their daughter was driving the car and ran the red light, or that that they shouldn't be held responsible because it wasn't them that was driving, it was somebody else. So I don't think that this is a new concept in the law, but the idea is that owners of the property are the best people in the position to control their property and should be held, and it is okay to hold them liable for the wrongdoing of others on that property. I just briefly wanted to touch upon the preemption issue. Mr. Onsbacher did not address it, but I don't think that there's any serious argument that this ordinance is preempted by state law. This ordinance just simply requires the landlords to evict tenants in compliance with state law, to pursue any legal remedies that they have under state law. It simply supplements state law. It does not conflict with state law.
Just hypothetically, what if a landlord rented first to one person, then to another 6 times? Each time a drug sale occurred and some sort of code enforcement proceeding resulted in points. How and when, if at all, can the landlord demonstrate that despite the 6 points, I had no knowledge or reason to believe that these activities were going on?
Again, the defense of no knowledge is not a defense under the city's ordinance.
So you can't do it at the hearing. Can you do it at any time, anywhere?
No, I think in that case where you've got multiple tenants, and I mean this is just going to the issue of whether the landlord would be required to evict all the tenants, even though some of them may not have engaged in the wrongful activity. I don't think Florida law would allow for that, and I don't think they'd be required to do so under our ordinance, if that answers your question.
Can they avoid action against the permit by showing that scenario? And if so, when do they do that? In what proceeding?
The landlord would not be able to avoid action under the ordinance based on not having knowledge of different drug activity. Well, drug activities are not a covered activity under the ordinance. It's only 7 activities, which are litter, noise, and that sort of thing.
Does it defeat your argument to concede that, in fact, there are some circumstances in which the application of this ordinance might be unconstitutional?
No, I do not think so, because I think, as I started off with this argument, is that it is the appellant's obligation on a facial challenge, this is not an as-applied challenge, to show no set of circumstances exist under which this ordinance can be applied in a constitutional manner. And I believe that this ordinance can be applied in a constitutional manner, and I think that if it ever is applied, it will be applied in a constitutional manner. Your Honors, the city's landlord permit provides adequate due process and is not preempted by state law. Therefore, the city respectfully requests the court to uphold the city's landlord permit ordinance as facially constitutional and affirm the judgment entered in favor of the city by the trial court. Thank you.
I have the red light.
You had 4 seconds if you have anything to say. Nothing? Okay. Thank you both. That concludes the court's calendar for today. We are adjourned.